And thank you, Fred Lennon, master of the soft sell. It's a great privilege for me to be with you tonight. And Fred, I just want to say that I'm honored to be introduced by you. I don't know of anybody who has been more generous, more supportive, and a more invaluable ally of our president than Fred Lennon. And I think you're awfully lucky to have him as chairman of your board of advisors. And I feel very fortunate to be here with Gene Ashbrook this evening in this very important third memorial dinner here. And to be on the same platform with such luminaries of conservatism as Bill Rusher here and Victor Lasky and Phyllis Schlafly is indeed an honor. I was very pleased, really, when my good friend and the director of the center, Cliff White, invited me to be here, and I am very grateful to him for his message. And I also would not want in my introductory comments to avoid thanking particularly Tom Van Meter and Ed Lozig, who's sitting down here, for making the arrangements for Ursula and me to be with you tonight. You know, it's good to be here for a lot of reasons. And I'll go into some of the more serious ones later, but one thing is just good to be out of Washington. You know what the president says, Washington is an island surrounded on all sides by reality. And it's good to be here and talk to you in person. Sometimes in Washington we get the sneaking suspicion that what we're doing there and why is not always faithfully conveyed to you by the news media. You know, we have a little story that kind of illustrates this. The story is told that one day a couple of our scientists were looking through their telescopes, and they saw a meteor hurtling towards the Earth. And by their calculations, they figured that within 24 hours, the meteor would strike the Earth, and immediately civilization as we know it would be wiped out. And the story goes on to say how this would be covered by the various newspapers. The New York Times would have a little box on page 1 that says, "World to end tomorrow, see page 14. The Wall Street Journal would have in that upper left-hand column, it would have rather large headlines for the Journal. It would say, "World to end tomorrow, markets to close early." USA Today would have a full-color graph on the front page with the headlines, "World to end, how we really feel about it." And then, of course, our good old Washington Post would have banner headlines, "World to end, Reagan tax cuts blamed." Well, in any event, I'm glad to be here and to be able to talk with you in person. And I'm particularly, most of all, honored to be part of this group which is joined in commemorating the memory of a great patriot, John Ashbrook, and where all of you are working together to build and expand this great center for public affairs to benefit all Americans who are today freer because John Ashbrook had the courage to light candles when too many of our citizens were only cursing the darkness. You know, President Reagan, I think, summed it up in that first memorial dinner in May of 1983 when he said, for John Ashbrook, conservatism was not so much a political pressure group as it was a modern reflection of the insights and wisdom that began the American Republic. His career as a public servant is testimony to this kind of enlightened conservatism. Well, that's certainly true. In the long years in the 50s and the early 60s, when some people said there was no such thing as a conservative tradition in America, John Ashbrook worked tirelessly to advance the principles, the fundamental values of America that he loved so well. His was one of the first voices that was raised against what he called the state planners, the economy wreckers, the spenders and destroyers of local government. But John Ashbrook didn't just talk about his concerns, he took action. As a founder and chairman of the American Conservative Union, and then later as a congressman, he fought to see his ideals become a reality. And as you know, he was lucky in that he did live to see the dawn of the triumph of those principles and the values in American public life. Now, through the dedication of you, as many friends and admirers, the John M. Ashbrook Center for Public Affairs stands to continue the work that he so nobly began. Through the center's interdisciplinary studies program, through the internships, through the distinguished guest lecture series, And through the scholarship program, this center is making and will continue to make an inestimable contribution to the conservative intellectual movement and indeed to the nation itself. Indeed, John Ashbrook was one of those men of whom it can be truly said he made a difference. Well, what John Ashbrook started, and many others with him, there are people here like Bill and Phyllis and Victor and others who went through that period with John. What they have started, many others have now joined and are continuing today, both in Washington, D.C. and around the country. It's been my privilege to serve for the past 4 years with one of those people, the President of the United States. And it was my great fortune when he asked me to assist him in a new position some time ago, the position of Attorney General. In the short time that I've been on the job, I've found this to be a very challenging and complex assignment. As a matter of fact, I think it was best summed up by my predecessor, Bill Smith, when he said, "Ed, there are going to be some days you feel a little bit like the captain of the Olympic javelin team who won the toss and then elected to receive." Well, for all of its special and unique challenges, there's at least one thing about the job of Attorney General that I have in common with every other person who serves in public office, and that's the simple oath that is taken before you begin work, in which we swear to support and defend the Constitution of the United States and to faithfully discharge the duties of our offices. Those few words in our oath impose a responsibility on everybody who takes it. The lawyers, the secretaries, the members of the armed forces, and even Supreme Court justices, everyone takes that oath, not only to support, but also, as the oath states, to bear true faith and allegiance to the document that is the blueprint for our form of government. Tonight, I would like to suggest to you that in both law and government today, there have been and continue to be serious threats to the intent of the framers of our Constitution, threats which must be resisted by those of us who agree to bear true faith to the masterwork with which those framers fashioned. And I'll suggest further that one of the most important challenges before the administration generally, and one of the things to which the President is personally very dedicated, and something which we in the Department of Justice feel is our particular mandate, is to move law and government in the direction of the faithful interpretation of our Constitution. The reason I selected this subject tonight is that on Wednesday we celebrated Law Day. Many of you who are here tonight are lawyers, and many are judges. Law Day is a day in which we stop and recognize the constitutional heritage of our country and the rule of law. And so I think it's appropriate tonight to consider these concepts in the context of this event and the John Ashbrook Center. During the last several decades, at the same time that John Ashbrook and others began leading a political revival that is moving our elected branches of government back towards fundamental values, there was also another movement going on. Certain of our officials, including some legislators and some judges, were quietly working a revolution of a quite different kind in our government. In a series of so-called landmark decisions, the courts, and particularly the Supreme Court, were changing the landscape of government in a way that the Founding Fathers would almost never recognize. The results in these cases were, I believe, well-intentioned. In some cases, the consequences were probably not fully contemplated. Still, in many areas, constitutional law came to resemble more what particular judges and justices would like it to be, rather than what the framers of the Constitution had intended it to be. Maybe that's what happens when judges start reading and listening to what other lawyers and other judges have to say instead of going back and looking at the Constitution itself. Now, naturally, there is not enough time this evening to fully expose the course of several decades of judicial activism. But there are, however, 3 cases that I'd like to talk about which stand out in my mind as an example of a trend in the courts that paralleled a similar departure from traditional principles of constitutionalism that existed in the executive and legislative branches for too long, but where now at least we're seeing a change. The first of these cases arose of all places here in Ohio. In 1961, the Supreme Court decided a case called Mapp against Ohio, the famous case of Dollar E. Mapp. In it, the court created a totally new set of restrictions on state and local police departments. They said that when an officer makes a mistake, whether in good faith or bad, any evidence obtained through that mistake cannot be used in court. This is called the exclusionary rule. It means that evidence cannot be used against the criminal, no matter how reliable it is, no matter how insignificant the technicality that was not met by the policeman. And what has happened in the ensuing years since 1961 has been that the web of technicalities has grown and grown, and even we've had cases where an officer was validly obeying the law at the time that he made an arrest or seized some evidence, and later on the court changed the law, said he was wrong, and turned the criminal loose. It means that the people who pay for the mistakes that a police officer might make, or even what a police officer does that is later said to be a mistake, are the public, the citizens, the law-abiding people in the United States. Now, there are a couple of interesting things about this case aside from its effect in undermining public confidence in our courts and in our system of justice. The first is that the Supreme Court itself has decided only 12 years before the Mapp case that the Constitution did not require the exclusion of evidence that had been mistakenly seized by state and local law enforcement officers. So I guess something changed and the Constitution meant something different in 1961 than it did in 1949. The second thing is that in the Mapp case, the lawyers who were arguing the case before the Supreme Court did not even think that the exclusionary rule issue was even thought to be a major question in the case. In other words, the Supreme Court reached out to decide that issue. It abandoned nearly 200 years of contrary precedent to impose a wholly new requirement and impediment on state and local law enforcement officers. Many years before this case came out, and this wasn't a new issue, Justice Cardozo had posed the question, should the criminal go free because the constable blunders? Well, unfortunately, in Mapp, the court answered yes. Now, I want to be very careful that you understand my concern about this case. Certainly, there were and there are cases of police misconduct, and they have to be very carefully handled. They must be addressed with vigor, and punishment should be meted out where it is due. But nowhere in the Constitution does it say that they must be addressed in a way that benefits only the criminal, and nowhere does it say that it is the court and not the legislature which is defined that way. Aside from the tremendous extension of judicial power that Mapp created, there is another profound irony about that case. It is that the Supreme Court, in its opinion, expressed that quite apart from the constitutional considerations, it was necessary to create the exclusionary rule, as it said, to preserve judicial integrity. And yet there is perhaps no case in the history of the Supreme Court which has done more to undermine judicial integrity in the minds of the American people than this decision. Fortunately, in recent years, the exclusionary rule has come under attack from both inside and outside the court. In fact, we have recently seen a willingness on the part of the court to create a good faith exception, which will keep evidence in court where the police officers make an honest mistake in carrying out their duties. And in a recent case, I was happy to see that the court said that for the first time in recent years that we have to balance the public safety against the rights of the individual criminal. Well, let me turn to another field and another case. The second case I'd like to mention came a few years later. It too created tremendous new judicial power, although in a very different way. In a case called Baker against Carr, the Supreme Court decided that it was now within the power of the federal courts to decide how state legislatures should be apportioned. For almost 200 years, the courts had acknowledged that there were not only things that they should not do, but that there were things that constitutionally they couldn't do. Among the latter was trying to settle political battles, particularly among elected officials. But in the Baker case, and in several subsequent cases, the court decided that it could do this and do it in a way that would supposedly make apportionment problems end. ignoring the primacy of the state constitutions, many of which actually had existed before the federal Constitution, the court threw out the apportionment process under which state legislatures had been apportioned, and under the catchy slogan of one person, one vote, threw out the sensitive history that was the basis of all two-house state legislatures. Out of the window went all consideration of traditional political boundaries, of preserving municipal and county lines as electoral lines, or of balancing competing interests within a state. Well, a funny thing happened, or really didn't happen. More than 20 years later, we're still trying to find out what one person, one vote means. We're trying to find out if legislative districts should be drawn to include equal numbers of men and women, or should there be equal numbers of old and young? Should there be equal numbers of Republicans and Democrats? Indeed, instead of legislatures now conducting redistricting, we have the courts doing it, and with certainly less effectiveness and less confidence on the part of the people. Instead of bodies of dozens of elected politicians making these very highly sensitive political decisions, we have appointed judges, often only 3 in number, squabbling among themselves on the same political questions that plague the politicians, and then imposing a result that doesn't seem to satisfy anyone. It's not as though the courts weren't warned. Justice Frankfurter, in arguing in his dissent against the consequences of the Baker decision, said, "There is not under our Constitution a judicial remedy for every political mischief, for every undesirable exercise of legislative power. The framers, carefully and with deliberate forethought, refused to enthrone the judiciary." Well, now in the light of hindsight, even some of our liberal friends are beginning to see this. Last week, a member of the Washington Post editorial board and the co-author of the Almanac of American Politics wrote a column on the impossibility of the courts finding answers to the problem of redistricting. He concluded that the courts had better simply leave politics to the politicians. Well, that's good advice, but it's 20 years too late. The mistake in these decisions is the idea that somehow the Constitution consists of only 2 words, do good. Judges who believe this notion naturally find in the Constitution a blank check. The trouble is that such blank checks end up with precisely what the Founding Fathers sought to prevent, and that is a government of men rather than of laws. One person's good may be someone else's evil. The genius of representative government is that it allows bitter controversies to be fought over and decided. The decisions of one legislature can be overturned by the circumstances of another, as conditions change and as the voters change the legislature. But things aren't so easy with Supreme Court opinions. And then, of course, the most unbridled and, in the opinion of many, the most tragic decision, the most egregious exercise of judicial power came just a bit over 10 years ago. In the case known as Roe against Wade, the Supreme Court in one stroke not only purported to make abortion on demand a constitutional principle, but it unmade the law of 50 states. People can and do disagree about the issue of abortion, but what is remarkable about this case is that it prompted an unprecedented attack upon the judicial activism of the court from legal professors and scholars of virtually every political stripe. Even many of those who personally favored legalized abortion were astounded and found that this opinion was a wholly unsupportable exercise of naked judicial power without any basis in the Constitution. Well, these are 3 cases, and cases aren't particularly interesting usually, but I think these are significant. One having to do with crime, one having to do with the structure of state government, one having to do with the sensitive issue of human life. These cases should focus our attention on this week in which we celebrate Law Day, on what sometimes passes as constitutional law these days, and how much it has strayed from the primary texts of the constitutional democracy which we have known for most of the history of our country. Now, it's true there are some people who will say that a modern age requires progressive and more efficient measures in our court decisions to keep pace with a complex society. Our founding fathers were less interested in efficiency than they were in liberty. They were greatly concerned about checks and balances, about creating a system of government with carefully defined and very limited powers. Again, to quote Ronald Reagan in May of 1983, it was John Ashbrook's insistent claim that the principle of limited government was America's greatest contribution to constitutional and political history. Well, that's the kind of government that we in this administration, and particularly in the Department of Justice, understand and want too. It's the kind of government that Representative John Ashbrook understood and dedicated his career to fighting for. Curbing the growth and power of government is not limited to the executive branch or the legislative branch. It means more than cutting spending or eliminating wasteful programs or lifting the burden of regulations, although these clearly are important tasks. It also means returning and limiting the organs of government to their proper spheres. It means appointing judges and pursuing policies that reflect the reverence that our founding fathers had for constitutionalism and the rule of law. Achieving these goals requires dedication and perseverance, the kind of dedication that Congressman Ashbrook demonstrated in his many years of public service. Of course, the task of restoring a balance, a constructive constitutionalism, if you will, is large and complex. It is one thing to understand the dimensions of a particular decision. It is another to try to change that decision. Our efforts in this regard must at all times be informed by good judgment and a sense of what's possible. Nevertheless, we must undertake these efforts if we are to be true to ourselves, to our oaths, and to the Constitution. It's interesting to note that conservative philosophy and the return to traditional values is now the mainstream political thinking of the American people. I think this was proved in 1980. It was verified in 1984. Now it's time to make sure that the judicial decisions of our country also reflect that return to traditional values. Through legal advocacy, legislative initiative, even constitutional amendment, if necessary, to overcome judicial misinterpretation, we must steadily seek to return our courts and our laws to the fundamental principles of the Constitution. This task won't be easy. It's not a challenge that is subject to a quick fix, but it is essential if our constitutional system and the rule of law, not of men, is going to prevail. Perhaps we can be encouraged a little bit in this task by these words of Goethe, who said, "Heard are the voices, heard are the sages, the world and the ages. Choose well. Your voice is brief and yet endless. Here eyes do regard you in eternity's stillness. Here is all fullness. Ye brave, to reward your work, strive and despair not." Well, John Ashbrook was one of those who chose well, despaired not, and worked hard. All of you choose well by honoring him and by continuing his work through the Ashbrook Center. Thank you for honoring me tonight by letting me join with you in this tribute to him. I knew John Ashbrook very well, have great admiration for him, and so I'm particularly honored to have been asked to participate in this evening's event. With that, I'll open it up to questions.
Mr. Attorney General, your Justice Department in Cleveland has sent a recommendation to your office suggesting that Jackie Presser be indicted. Have you made a decision on that?
Well, one thing we do is that unless there's some point in an investigation where, by law, a matter becomes public, we don't comment on an investigation, whether there is one or is not one, or any aspect of it. So it would not be appropriate for me to comment under either circumstance. Yes?
Mr. Meese, I was wondering, what is exactly the status of the E.F. Hutton situation, as well as the government's intervention with the FBI in Operation Rough Rider?
Okay, the E.F. Hutton situation is that yesterday in federal court, in the Middle District of Pennsylvania, E.F. Hutton entered a guilty plea to 2,000 counts of mail and wire fraud and agreed to pay a fine of $2 million to pay the costs of the federal investigation in an amount of some $750,000, $750,000. They also agreed to and received an injunction by the court prohibiting them from engaging in anything like the check-kiting scheme that they had been involved in, and also made them give certain reports to the banks with which they deal to prevent such a scheme from ever happening again. They also agreed to set up a victims' compensation fund to provide restitution to any of the victim banks that might have been hurt or who were defrauded and suffered a loss during the 2 years in which the scheme was operating, 1980 through 1982. So basically, as far as we're concerned, the investigative and prosecutorial aspects of the case are closed. It is now a matter for the correctional aspects of it, the serving of the sentence, that is the paying of the fine, the handling of the restitution, and of course we will be monitoring it to make sure that the injunction is being obeyed. Now, as far as Operation Rough Rider, this was an outstanding investigation over several years by the FBI using most sophisticated undercover techniques, which has led now to the indictment of some 100 and it's well over 125, I think it's 133 or thereabouts, members of the Hells Angels motorcycle gang, an organized criminal conspiracy. I think there's over 100 of the people for whom warrants are out have already been arrested, and this will now proceed to trial. It's at the point where people are being apprehended. They'll be probably either released on bail or held without bail, depending on the circumstances, and ultimately will go to trial. Yes?
Mr. Attorney General, regarding the recent criticism of President Reagan's trip to Bitburg and also the recent criticism coming from Capitol Hill concerning several of his measures, both budgetary and aid to Nicaragua, how is this affecting the President personally?
Well, I think that the President remains cheerful and optimistic. I saw him just before he left for Germany. We talked a little bit about this, as a matter of fact, and he said that he thinks that ultimately the American people understand what he's doing, why he's doing it, and that he will be successful. So I would say he continues to be cheerful and optimistic, which has been his mood, I think, pretty much through the presidency. That's why he looks so young.
Mr. Attorney General, recently we had a collapse of a securities firm in Florida, DSM, and the resulting loss of millions of dollars to many cities around the country. Given what you do on EF, exactly how much of a focus are you going to put on the white-collar crime like this, and what do you see coming out of the ESM case?
Well, white-collar crime, or economic crime as it's more appropriately known, is a major focus of the department. It's one of our primary criminal law objectives, along with narcotics and organized crime and terrorism, so that it gets a great deal of our attention. I think some 25% or more of the resources of our investigative agencies are devoted towards this kind of crime. We have just, for example, developed a new bank fraud system with the financial institutions regulating agencies such as the FDIC and the Federal Reserve Board, Federal Home Loan Bank Board, and others to work on both the prevention and the detection of economic crime. So it is a major thrust. That's why this E.F. Hutton case was so important, because there was a case where we could demonstrate to the business community that that kind of activity will not be tolerated.
Once you know of ESM,
yeah.
do you expect people to go to jail, and have you reached any opinion on the role of Marvin Warner?
Well, at this stage, I wouldn't want to comment on an ongoing case that's in the process of investigation and prosecution, so I wouldn't want to answer that case, except that it will, of course, be vigorously handled.
With the defense budget rising and the exposing of fraud on the military contractors part, charging so much for a hammer, what is the federal government going to do with these contractors?
Well, this is a part of the economic crime. Defense procurement fraud is a major aspect of economic crime, along with bank fraud and these other types of offenses. So we have a special unit in the Justice Department that works with the Defense Department just to ferret out, investigate, and prosecute those kinds of crimes. Now, I think you have to distinguish between those cases where there are legitimate contracts, which may not have been negotiated as carefully as you might want, but where there is where people can argue about whether this was a good deal or a bad deal for the government, but the contract is legitimate. That is a matter then for better contract negotiating. But there are cases where there is actual fraud. That is where the wrong parts or materials are used, or where there's overcharging for labor charges or for other kinds of charges, where there's actual fraud or wrongdoing, where the government has been harmed, the taxpayers have been hurt. These are the ones that we go after where there's criminality and an intent to defraud the government. Yes?
Getting back to the issue of E.F. Hutton, New York Mayor Edward Koch today criticized the action because he felt that there weren't enough individual indictments involved with that case. What's your reaction?
Well, the mayor obviously couldn't be informed on all the facts of the investigation, but if you look into it, what you find is that there was a certain number of people involved. It was a relatively small number of people in middle levels of the management of the organization. They were not up at the board level or the executive level. And in the course of the investigation, it was necessary to grant immunity to some of these people. But the important thing was it was a corporate fraud. It was a corporate scheme, and it was only the corporation that really benefited from the criminal acts themselves, and that's why we felt it was more important to expose this. If the investigators who handled the case had not granted immunity to some of the people, they would never have been able to ferret out this very complicated scheme. So sometimes in these difficult investigations, which are particularly complex, and this is true of many of these things, it's more important to get the corporation, to get the large fine, to get the injunction, to get the victim's compensation, which you wouldn't have been able to do if you charged individuals, not granted immunity. You probably never would have gotten to the bottom of the scheme in the first place. And secondly, you would have had a prolonged trial over 3 to 5 years with questionable results. Anybody else?
Attorney General, the 15th anniversary of the Kent State shootings. I wonder, if you look back after 15 years, what you see as the significance of that, and exactly how Reagan administration might act toward the college campus as compared to, say, the Nixon administration 15 years ago.
Well, don't forget, the Nixon administration was not involved in the Kent State situation. This was a matter of law enforcement within the state itself, and the entire incident was handled by state forces. I guess in this case it was the National Guard, along with other police agencies. I think if you look back, you see that there was a real period of great tragedy. I think there was a tremendous misunderstanding among many of the students as to what the issues were. A lot of people were dragged along into it who probably on reflection today would not have been there at that time. I think and as a result, excesses, direct confrontation with authority, violation of the law, led to these tragedies that occurred during that period of time. And I think we look back on a period where we hope the students who were involved then and other students looking back will learn the lessons that probably that's not the way to go.
We had a storming confirmation here in the Washington Post poll recently showed that 38% of the people approved your nomination, 43% opposed it. Do you think you're going to be able to overcome this resentment among the people, and what exactly do you feel?
Well, I wasn't surprised by the poll at the time because all the publicity had been rather one-sided, and I think that I have no doubt at all in my mind that I will be able to carry out the duties, and I'm very hopeful that when the people see the facts and also see the type of work that we're trying to do in the Justice Department, that their views will be supportive.
Sir?
Yes.
Is the focus of the department going to change as far as dealing with racial discrimination cases and/or environmental cases from the Smith regime?
I don't see any major change in the focus. We are absolutely opposed to discrimination, and since under my predecessor, William French Smith, the Justice Department had the greatest record of prosecution of discrimination cases ahead of virtually any other administration. We will continue that. Wherever there is discrimination, we will vigorously prosecute it. Likewise, in environmental cases, there was a great deal of enforcement activity that was initiated during this period of time. And we have a whole division of the department whose primary mission is to work with EPA and with state agencies in the enforcement of the environmental laws.
It seems that so much focus in a criminal case is put on, let's say, the suspect's rights. What is the national government doing to help out the victims, if anything?
Well, we're doing a lot of things for victims. We're for the first time in the Comprehensive Crime Control Act of 1984, we developed a Victims' Compensation Fund, where when federal defendants are convicted, a part of their fine and a part of any other penalties that are assessed goes into a Victims' Compensation Fund, which is then sent out to the states to help defray the expenses and the costs of crime victims and to help make them whole. We also have a series of victims assistance programs that we are promoting both directly in terms of the federal judicial system and also assisting states with victims assistance programs within their jurisdiction. But I think as far as what you mentioned in the courts, we're also advocating, both through legislation and in cases before the court, a balancing between the public safety on the one hand and the rights of individual criminal defendants on the other. And I'm happy to say that for the first time in a recent case last year, the court held that such a balancing was a way for the court to do a better job of handling criminal cases. Yes?
So how actively will the department be pursuing, investigating the ties between labor unions and criminal activity or organized crime?
We will continue to pursue this very vigorously. This is part of our overall campaign against organized crime and drug enforcement and drug trafficking. We have both the regional organized crime drug enforcement task forces which are working in this field against the organized crime rings, and we will continue our strike forces which particularly are ferreting out these labor law violations involving organized crime.
Do you agree with the characterization by some people that the Teamsters Union is dominated by gangs?
I don't think it's appropriate for me to characterize any group or organization unless and until they have been convicted of crimes.
As one of President Reagan's closest advisors, what is the President's feeling for the first time in history that the United States has a trade deficit?
Well, we have a trade deficit that has been growing for a number of years, certainly before he took office. The reason for the deficit is manifold. We've had some very impressive task forces working on this for the last 3 years, and they come in with some steps that we have to take. His feeling is that we should not have a trade deficit and that we have to take firm and vigorous action. That's what he's talking about over at the Economic Summit right now. One of the things we need to do is have a new round of trade and tariff negotiations to break down trade barriers and to adjust the trade relations in the free world. A second thing we need to do at home here is to improve our competitiveness. We do this through education, we do this for research and development, we do this through deregulation, less government regulation imposed on our businesses and industries and labor unions. So there are a variety of things that we're doing right now, but we're very concerned about it, and we're trying to take the steps that will change that adverse trade balance. Anybody else out there beyond the lights? If not, thank you very much.